September 6, 2012 This is Justice Done Dirt Cheap in Fredericton, New Brunswick. I just wanted to give a quick video regarding some procedural issues. And when one is responding to a motion filed by another party, they're considered or known as the responding party. One has an opportunity to file affidavit material as evidence to be used in their own defense or to defend or to forward their legal position at the hearing of that motion. According to the rules of court, one has 4 days before the hearing to actually file and serve all the material that will be used at that hearing. And the rules of court do not require that a brief be filed on a motion, though one can prepare a brief, and it's actually in one's interest to do so. With a brief, one has an opportunity to get their thoughts in order, to write a very clear, concise, to the point submission that has quotes to the relevant case law and authorities supporting the legal position, which should help them win the day. If basic jurisprudence and legal procedures being followed in the courts, which doesn't always happen. So anyway, what happened today is I had to file a I decided to file a brief and a affidavit to defend my position and support my legal position, which I did. Filed it in the morning, and then I served the paperwork on the party who's what's considered the moving party of the motion, which is a solicitor representing the city of Fredericton and others. That is Leanne Murray of McGinnis Cooper on Queen Street, Fredericton, New Brunswick. I took those documents, which I filed, and then served them on the office of Leanne Murray at McGinnis Cooper. What's interesting about serving a solicitor of record is that once you know who the solicitor of record is, one does not have to actually make arrangements to personally serve that solicitor or personally serve any other parties to the litigation. If one is represented by a solicitor, then those parties represented by that same solicitor can be served by providing a copy to the office of that law firm. So one simply has to walk in with a copy of the documents and a cover letter so the solicitor knows what the documents are concerning. Now, it should be fairly obvious from reading the documents, but just to be sure, make sure one provides a cover letter explaining what the documents are, when they were dropped off. And then also what's good to have is called an acknowledgement of receipt card, which the secretary or receptionist, depending on the size of the law firm, will fill out, stating their name, who they were, the date that the documents were received, so one has proof of service. Then one goes off and fills out an affidavit of service. An affidavit of service is fairly simple. The format can be found in the forms from the Forms of Court on the Government of New Brunswick website. And it's a pretty simple matter where one is stating, I, so-and-so, and it states where you're from, what you do, and what the date is, did on such and such a date serve, and the documents are listed of what was served, when, to whom, and the circumstances surrounding that service. One includes a copy of the actual documents which are served as Exhibits A. If there's more than one document, one can have Exhibit B, C, D, E, F, G, as many documents that were served at the same time. And one goes to a commissioner of oaths or a solicitor and has the document what's known as sworn out, where they swear that it's true, that everything's being said on the document is true, and they did those things being stated in the document. And once the affidavit of service is sworn out, then one makes copies of it, and then the affidavit of service must be filed with the clerk's office, where one provides the original and a copy. I recommend whenever filing documents to the clerk's office, always include a cover letter which states the date, the clerk's name, a summary of the documents being filed that day, which they're listed, so it's easy for the clerk to see what the file number is, who the parties are, what the matter's generally about, and the documents that were filed. So it's easy for, in this case in Fredericton, we have Craig Carlton as the clerk of the court, to make it easy for him to file documents, put them in the right hands, so to speak. If there's a judge that's hearing a motion coming up, the judge needs to have the material before the motion to be able to read through it, to be familiar with the material before the hearing. Filing documents, the sooner one files them, the better. Being late does not win you any favors with the clerk's office or the judges or just about anyone. The rules of court are the rules of court, though. If you have to file things last minute, then make sure you're at least adhering to the rules of court. Otherwise, we get into that situation where one has to actually file a motion for extension of time for service, which is a real simple motion, and it actually should be straightforward. And in most cases, the extension of time should be granted because jurisprudence on the subject, the rules of court, the philosophy of the courts, so many judicial decisions support granting an extension if necessary. But it's been my experience in the Court of Queen's Bench that's not generally granted to a self-represented litigant. So I just want to warn you there, just try to file everything on time, early if possible. And so I filed the affidavit of service to